Dharwad bench. Dharwad bench unmute ಮಾಡಿ.
ಹಾ ಮಾಡಿದೀವಿ ಸರ್.
ಸಾಹೇಬರು ಬಂದ ತಕ್ಷಣ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ನಿಮ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ. ಇಲ್ಲ ನೀವು ಲೈವ್ ಕೊಟ್ಬಿಡಿ. ವಿಡಿಯೋ ಲೈವ್ ಕೊಡಿ.
ಬಂದಿಲ್ಲ ಸರ್.
ಇಲ್ಲ ಇನ್ನೊಂದಿದೆ.
ಇಲ್ಲಿ ಯಾರು ಬಂದು ನಿಂತ್ಕೊಂಡಿಲ್ಲ ಇವತ್ತು. ಕೊಡಿ ಬೇಗ ಕೊಡಿ ಬೇಗ. ಸಾಹೇಬ್ರು ಕೂತಿದ್ದಾರೆ ಅಂದ್ರಲ್ಲ. For pronouncement of judgment in commercial appeal 140 of 2024.
The above appeal is partly allowed with cause. Interim applications and dispose of. Impugned judgment of the commercial court is modified as under. The impugned judgment insofar as it directs the appellant plaintiff to quit, vacate and hand over possession of suit property is affirmed. The appellant plaintiff shall pay the respondent defendants arrears of a sum of rupees 435, 55 to 48, together the interest at 2% compounded per month from 1/2/23 up to date of payment. Appellant plaintiff shall pay respondent defendants a further sum of rupees 827, 50, 000, together the interest at 2% compound every month from 1/7/20 up to date of payment. Modified decree to be drawn accordingly. Great. Continue.
Lordship permission. But serial number 68, my lords. In fact, the last occasion, my lordship pleased to hear KIDB matter, my lord.
List number 3 for pronouncement of judgment. Seal number 1, writ appeal 1203 of 2026.
In view of the above, the appeal is allowed and the impugned order is set aside.
Seal number 2, writ appeal 1948 of 2025.
The appeal is allowed in the aforesaid terms.
Seal number 3, commercial appeal 182 of 2025.
Here for the appellants.
You mentioning?
So sorry, Manoj, I didn't deeply.
My Lord, Pollution Control Board matter, date is given to August 20th, my Lord. My repetition file is, I'm seeking a direction for the State Pollution Control Board to consider my application for a consent of establishment of my stone crusher. The respondent had sought to seek instructions.
Yeah.
However, my Lord, they have issued a notice to RESCOM and they have cut my electricity supply.
All right. Take it.
Tomorrow. Very.
Can I make a request? List 1, seal number 37. Writ appeal, Lord, we have some urgency.
30.
Seal number 37 in the first list.
All right.
The urgency is not, we are about 160
This
buses.
is Karavali Bus Association.
Please, Lord.
This
Yes,
is the-
Lord. Yes. With regard to not this flying of buses, not the fast tag not charged.
That's right.
But we have some urgency because not every day we are suffering loss because of the double payment. Not.
That's all right. We'll see.
Please, Lord.
We have heard of, we have. Yeah,
No, at least can I request-
This will have to be heard.
But it will have to be heard. My only difficulty every day I'm suffering loss. Can I make one request, Lord? Can be if not today, can it be listed for preliminary hearing, not in any convenient date, not short date. Be listed for preliminary hearing on that day in list 2.
Like, we'll take it up only after these part heads are over. We have a reservation part head that's going on. That's why we won't be able to take it up today.
But next week, any day, Lord, in list 2, not subject to Lord's convenience.
Can't be taken.
My Lords,
Just give 37, just give it end of August. Try and take it up then.
but can it be?
7th August.
Can it be for preliminary hearing?
Yes?
Can it be here for preliminary hearing notes in list
So
2?
we'll finally dispose of, we know, we are
But my only request
familiar with
is,
what the controversy there is.
my only request is not if it comes in second list in preliminary hearing, not I'll take my chances.
Second list, we don't determine what comes in second list. So it's not it is only up to what can't come in the first list because of time constraints comes in the second list, which are only fresh matters and matters that are held over, that's all.
Please.
And 6 months he was granted to vacate the source premises. But now there is a difficulty to shift the business operation. We have filed an application to extend 2 months.
We can't.
And it-
This was by consent. If you have a consent order, you can.
But we have paid the amount.
We can't do it by consent. We can't alter a consent order without consent.
Yeah.
Anyway, you can move whatever your application. It will come up in its normal course.
My lords, I represent the council for the petitioners in 39.1, 39.2, 39.3 and 39.4. My instructions are that the learned council is not keeping well, my lord. I pray for 2 weeks.
Who's for the 13?
Lord, on our request, it was posted today. my lord.
That's right. It's a short matter. Request for adjournment is made by the learned counsel for the petitioner. The request is
12th of October, short date may be given, my lord. Last week it was there, my lord. We made a request for an early date, my lord. Matter did not reach. Matter did not reach, and we made a request for a short date, my lord.
a short date.
September 21st.
Your Lords. Your Lords, list 1, serial number 2, Your Lords. Senior's co-brother was admitted in ICU, Your Lords. So seeking 4 weeks of adjournment, Your Lordships.
Request for adjournment is in behalf of the learned counsel for the stated that this counsel is to advance submission is indisposed. List.
4th of November.
My lords, moving a memo, commercial appeal matter, they have arrived at a settlement. All other matters have been referred to mediation. This matter may be taken up tomorrow so that we can refer it to mediation.
Lordships kindly, my lord.
Grateful.
Commercial appeal by the state, my lord. The objections have been cleared. Lordship may have it on Friday, my lord. Execution is coming up on 1st September. 1st August.
1st September.
1st August, my lord. 1st August, it's coming up. Any date this week.
All right.
Your Lordship, counsel appearing for the respondent, Your Lordship. First list, serial number 24.
Yes.
Case may be adjourned, Your Lordship. The arbitration tribunal is passed the award in favor of the respondent, Your Lordship. So, the senior counsel is not well and is going to appear as early as possible.
Who's appearing for the appellant?
Dharanishwaran.
Actually, they were present. The counsel was present.
There are no objections.
There are no objections.
Request for learned counsel for the respondent. List on.
My lords.
So 4th of November.
Lords, serial number 18, my lords. List 1, my lords. Lords, there's urgency, it might be taken up, my lords.
My lord, serial number 18, my lord, I appear for respondent. My lord, we need some more time, my lord, 3 weeks time to comply the orders, my lord. That is my instructions, my lord. I have taken. I informed the other side also.
Just say learned counsel appearing for the respondent seeks 3 weeks time to report compliance. That is request list.
My lord,
43, my lord.
serial number 43, my lord. I'm appearing for the complainant. My lord, the writ petition order is complied. The same may be dismissed as infructuous, my lord.
Learned counsel appearing for the complainant submits that the order, the disobedience which was alleged has been complied with, and the petition may be disposed of. Complaint is accordingly closed.
Serial number 3, my lordship. List 1, serial number 3, my lordship. Will be taken on next week, my lordship. Some personal inconvenience. 3, list 1. For the appellant.
This is listed for a preliminary hearing.
Please, there is a chances of settlement also, my lordship.
Lords, I'm for the caveat.
Yes.
I'm not being served with the appeal copy, my lords.
Please, sir.
Learned
I will serve the copy.
learned counsel appearing for the appellant states that the parties are endeavoring to resolve the disputes amicably. Request for adjournment. List on that. Meanwhile, the copy of the present appeal be served on the learned counsel for the response.
So 5th November.
Please.
With your lordship's kind leave, serial number 12 in
In
the
fact,
first.
in item number 3, say issue notice, learned counsel for respondent accepts notice, and then say this.
Serial number 12 in the first list, please, my lords. I have to file a better affidavit. I could not file within time, please, my lords. Maybe please permitted to a week's time, please, my lords.
You're not, nobody is visible here.
I apologize. My lords, I appear for the accused in serial number 12, please, my lords. List 1, serial number 12.
Yes.
I seek for a short accommodation, please, my lords. I have
Who's
to file my
appearing?
better affidavit, please, my lords.
Who's appearing for the appellant?
Anu Parnally.
Complainant.
Anu Parnally.
I shall inform, please, my lords.
Request for an adjournment is made by the learned counsel for the accused. At a request this time.
So 28 September.
Grateful.
Any other mentions?
Come from list 1.
So list number 1, seal number 1. Mr. Nayak VS.
Appearing for the complainant. Notice.
Fourth November. 2 and 3 are urgent. Seal number 4.
Order dated 13/12/24, my lord, has not yet complied. Lord,
My lord, in this matter, we have filed a complaints affidavit earlier, but it does
kindly
an
see the
endorsement
minority.
issued. I request your lordship some time for filing a better affidavit and issuing a better endorsement.
Learned counsel appearing for the accused seeks time to file a better affidavit. The request list 1.
It is 28 September. Seal number 5.
My lords, I appear for the accused. My lords, the principal amount, my lords, the EMD and the security deposit, my lords, that was due under the order of the learned single judge, my lords, is paid. What remains is, my lords, is the interest part. My lords, there is a slight difference, my lords, in the calculation of the interest, my lords, as per the complaint and the institute. My lords, we are working on that. My lords, another week or 10 days time, my lords, will resolve it, my lords.
Lord, will file a memo of calculation. The amount, my lord, is not completely paid.
Learned counsel appearing for the accused states that all amounts have,
Principal amount, my lords.
all amounts have been paid other than the interest.
Yes, my lords.
Also, there's some discrepancy in the calculation, and the same is being resolved.
Week,
That is
next week.
request. I request this time.
28 September.
Obliged.
Seal number 6. I appear for the complaint in this matter, my lords. So matter was posted for filing of complaints affidavit, my lords.
Yes.
My lord, the direction was to conduct the investigation with respect to an incident happened between the petitioner and the respondents. We have conducted the investigation and charge sheets have also been filed. I produced the charge sheet copy along with the documents. The operative portion of the direction, your lordships will get at page 37.
Yes. Maintain status quo.
Please move. Subsequently, there's an order in the MFA also at page 39. The station house officer was called upon to
Yes.
file the records.
Submit a report.
The allegation is that, my lord, that in spite of the status quo order, some violence happened between the petitioner and the respondent, and an FIR was lodged. I have filed a copy of the FIR with my affidavit filed today. Serial number 6. 434. Now, the statement of witnesses have been recorded. In certain documents also, Mahajar also has been conducted. Document number 3 is the spot inspection. Document number 9 is the charge sheet.
Yes, we'll take that into record.
My lords, one submission, my lords, may.
Yes.
My lords will go through the affidavit, my lords, and make our submission, my lords. And also there are private parties in this, my lords. They may have to necessarily file an affidavit, my lords.
No, now they say that in the report that both the parties have decided to put one lock each and maintain status quo. Unless you are disputing that, that's not the case.
Please, my lords.
They've already reported that both parties have agreed.
Very well, my lords.
Your Lordship, counsel for A1 to A9, Your Lordship.
Yes?
A1 to A9.
Yes, let's take that. So, Laurent.
Counsel for.
Accused. Number 15 is filed in compliance affidavit. The same is taken on record. Full stop. In view of these, in view of the above, the present complaint is closed.
This is number 7.
Great.
I appear for the complaint, my lord.
I take notice for A2 and A4, my lord. It appears that, my lord, they'll have to amend the cost title so as to bring in GBA and Concerned Corporation, my lord, and Deputy Commissioner TDR.
With regard to the same, I shall file a memo, my lord. The same may be permitted to amend and implement the GBA, my lord.
Without they amending it, my lord, I am not in a position to file my power also. It's the reason.
If they want, you want that to be, them to amend it and introduce.
Please, my lord.
You want them to amend the memo of parties.
Yes, my lord. They'll have to amend that, and thereafterwards I can secure instructions and then file my power also to that effect. In the meantime, let them be directed to serve set of papers on me.
You will appear for GBA.
Yes, my lord. GBA as well as since A2 is BBMP and A4, my lord, is the Deputy Commissioner TDR of the BBMP, earlier BBMP.
Yes.
So they'll have to amend it appropriately and then find out, I'll have to take instructions from them.
No, BBMP, of course. BDA, definitely you're there, no?
Yes, GBA, I'm definitely there.
Also, BBMP is also there.
No, BBMP, my lord, is ceased to exist. In view of that, my lord, they'll have to array the concerned corporation where the particular subject matter falls. Because that is the recommending authority.
Senate counsel appearing for the complainant seeks time to amend the memo of parties.
Please, my
lord, I appear for A3 and serial number 7 to 11, my lord.
Let the same be amended within a period. Let the amended memo of parties be filed within the period. 2 weeks from date this time.
Please.
So, 25th September.
6 to 11.
7 to 11.
7 to 11. 12 adjourned. Seal number 13.
For complainant, my lord, in this case, my lord.
Ready to hand over the DD, Lord. Accused is the husband.
Lordship, there is a arrears of around rupees.
I'm ready to hand over the DD, whatever the order has passed this.
And
4 lakh.
this honorable court has ordered on 23/11/2024, my lord. Within 4 weeks, they have to.
The pending amount is
It is in
4,29,760, Lord.
execution, my lord. It is in family court. When he is evaded the notice with his powers.
How much is the total amount according to you?
4,29,760, Lord.
It is arrears in before the family court, my lord.
Yes?
Arrears before the family court, 4,29,760, my lord.
Yes.
In before this honorable court has ordered 25,000 per month, which is ordered on 23/11/2024, my lord. Order was within a four weeks he has to pay. Till now he hasn't paid anything, my lord.
Lordship, from 1 year, I'm
He's
ready
got
to
a-
hand over the DD, Lord. 4,29,760 was order, you, Lord.
The belated payment does not first the offense, my lord. He has to punishable.
4,21,000, 29,760.
4,29,760.
I'm ready to comply the order now.
You want it or no?
My lord, arrears, it has to be because
You want this or not, we'll record that statement that he's giving, rest he'll pay.
my lord,
Rest of the amount, if any, is pay, but you take that at least.
my lord, on submission, my lord. In execution also, he is a police sub inspector. He's evaded every notice which is sent by the honorable family court, my lord. From here, honorable court has ordered within 4 weeks he has to pay.
Yes.
From till now, he hasn't appeared before the court. He hasn't paid anything. He just previous date he said that he will pay. After that, he doesn't appear before this court, my lord.
From last year, September onwards, your Lordship, I'm ready with the DD, Lord. It's a 4th DD, I'm changing the DD. They are not receiving the amount.
This is to be deposited before the executing court, no?
No, Lord, please, your Lord. This onward court has passed the order saying that within 4 weeks, the respondent has to deposit this amount.
This
your Lord.
honorable court order also, my lord, which is around 23 lakhs rupees.
Let's see that order. Which one are you saying?
Lords,
The order, the disobedience of which you are alleging is 23rd of November 2024. That only says 4,29,000.
that is arrears of family court, my lord. Along with that order has.
For
I
that
have-
execution case has been filed, your Lordship.
In
Execution
MFA, I have filed one application for
execution case is
maintenance.
pending for consideration, your Lordship.
What is the date of filing that application?
My lord, along with my MFA, I have filed it, which is allowed on 23, my lord. I just a portion of the order, I will read it, my lord.
No, what is the date of the application? IA 1 of 2018.
My lord, 13/12/2018, my lord.
30?
13/12/2018. And also, my lord, I have filed an enhancement application before the family court. He
You're
hasn't
in
led his
condemned-
evidence in this.
condemned jurisdiction, so he has to pay you 25,000 per month.
Yes, my lord.
How much does that work out to?
Till now, it is 27 lakh, my lord. 23 lakh, my lord. Apart from execution.
Your Lordship. The execution, some of the amount has paid in execution court, your Lordship. That execution.
Nothing,
case
my
has-
lord.
that
I will
execution
place
case-
before this court,
that
my lord.
execution-
They
that
have
petition-
evided every notice. They have evided.
Let's hear
Please.
it.
The execution, after receipt of some amount, your Lordship, that petition has been disposed, your Lordship. After that, MFA has been filed, your Lordship. In the MFA, from the date of order, your Lordship, 4,29,000 has to pay, your Lordship. From past 1 year.
4,29,000 one amount. There's also in addition interim maintenance of 25,000 from 13/12/2018.
That amount will comply, your Lordship. That amount
Is what now, if you look at it, you're talking about 7 years.
Your Lordship, one execution petition has been disposed, your Lordship. Another execution petition is pending for consideration, your Lordship. The amount has
Tell us how much you have to pay as per this order. No, this
4,29,000.
order, read the order. You have an order of 23rd of November 2024.
From past 1 year, I'm holding the DD to give it to your lordship. They're
All
not-
right, this DD will.
But they're not receiving the
As
DD.
far
your
as,
lordship.
as far as DD is concerned, if they don't receive it, we will not proceed against you on contempt, that's all. But as far as the other matters are concerned, other amount is concerned, you have to pay.
It's bound to pay. I will pay.
How much you, according to you, have to pay?
Take instruction, I will, some amount I will pay you. lordship.
Not some amount. You tell us as per this order, how much according to you is payable in accordance with the order of 23rd November 2024.
We'll exchange the memo of calculation, then I will submit you.
My lord, if they have filed, if they have paid anything, which it is necessary for the memo of calculation, they haven't paid any single rupees.
How much according to you?
My lord, execution petition in 254 of 24, which is pending before the family court. In that, 4,29,760 rupees is pending. Then from this honorable court, it is ordered on 25,000 per month. Till now, it is around 23 lakh. So totally, it will around 27 lakh for.
You take this DD at least. Do you want? Otherwise, if you don't want, then you.
My lord, now my concern is it.
We'll have
He
to
is a
record
law
that he's
enforcing
offering you
officer,
a-
my lord.
We'll have to record that he's offering and the demand draft and you're refusing to accept.
No, my lord. I will. Just one submission, my lord. He himself is a police sub-inspector. He's a law enforcing officer. He hasn't followed the honorable court orders till now. If he himself is doing it, what is the concern of the others, my lord?
No. Do you want it?
Please, my lord.
Give it to him.
At least it should be at least 27. It is others of 27 lakh, my lord.
Are you taking it? Are you not taking it? We are asking you this simple question. You take it or you don't take it? The learned counsel for the response for the accused is handed over a demand draft of a sum of rupees 4,29,760. The learned counsel for the complainant. Full stop. The learned counsel for the complainant. Next part. Learned complainant submits an addition to the said amount. The accused is to pay a sum of rupees 25,000 per month as an interim maintenance, which is from the 13/12/2018. However, no amount is being paid as yet. Learned counsel for the accused submits that he would make some payments before. Within how long do you want? How long do you want?
Lordship.
How long do you want to comply with this?
4 weeks, your lordship.
Within a period of 4 weeks.
I'll let them furnish a memo of calculation, whatever remaining.
You take your memo of calculation, whatever according to you is payable, you pay that, and then you come. Otherwise, he's right. You can't not follow the order. This order is passed in
24/11.
It's 2018 order. 24 it has been passed. Oh, you know, almost a year, 2 years of one man.
Past 1 year, I'm requesting to take the DD, your lordship. They not received the DD, your lordship.
Yeah, tell him maintenance you have
Only
to pay,
this
no?
amount, my lord.
Pay that. List on put.
30th September.
Is a DD live?
Yesterday's DD, your lordship.
Yesterday.
December 14th.
Lord, I appear for the complainant in this matter, my lord.
Yes.
The state had preferred a review petition. State had preferred a review petition in this matter and it's pending for, it's listed tomorrow before the roster bench meeting.
Learned counsel appearing.
True, my lord. It's true.
Review petition listed before the court tomorrow. Request for adjournment, the request list.
29th October.
Obliged, my lord.
December 15. SB Mukkanappa.
And appears for the complaining.
Lord, in this matter, the accused number 4 has complied with the order.
Others may have to require.
In fact, different departments were given directions to pay the differential GST and VAT amount. Other departments are yet to comply with the directions. My lord.
File it, please.
Please.
Let's see it.
Please. 8th of October. Cell number 16.
the accused in this matter, my lords. We have preferred an appeal, my lords, which is at 423 of 25. The office objections have been complied today, my lords. We'll move a memo tomorrow for posting, my lords.
Senate counsel for the accused submits that they preferred an appeal, that accused preferred an appeal. That don't say it. That an appeal has been preferred against the order, the disobedience of which is alleged. Do you have the number?
423 of 25, my lord.
WA 423 of 25. Request this one. Dash along with WA 423 of 2025.
2nd November.
Public.
Serial number 17.
The counsel for respondent number 4 and 5 have recently come on record.
Yes.
Supposed to file the counter affidavit.
Panchayat, the answering.
None appears for the accused number 4 and 5. Minister of Justice re-notify.
So 8th of October. Millards, a shorter date, Millards. Considering Millards, they are trying to form layouts out of the land, Millards. There's a stay order by the learned single judge, Millards.
So 18 urgent. Serial number 19.
I'll make compliance, my lord, sir.
Hearing for the complainant, my lord.
My lord, I could not get it translated. I just received it, my lord, sir.
Translation.
Just received it, my lord, sir. Lords, the operative portion is at page number 10, my lords. The name of the husband has to be replaced with the name of the complainant, my lords. We have issued an endorsement that it would be carried out, my lords.
My lords, there was also a request that the site should be granted, my lord, accordingly. But the site has not been granted so far, my lord. Even the name has not been changed. The name is okay.
Let's see the operative part.
It is at page number 10, my lords.
Page number 10 is
Petition 11365 of 2021, my lords. Operative portion at running page 10, my lords. In the second paragraph, my lords, in view of the above, the writ petition is disposed of, directing the respondent BDA to enter the name of the petitioner instead of her deceased spouse.
and then consider the claim for allotment.
Yes, please. That is
Where
also
is
in
that?
the end. It is in the second paragraph, my lords. I may read, my lord. ಪ್ರಸ್ತುತ ಪ್ರಾಧಿಕಾರದಿಂದ ಡಾಕ್ಟರ್ ಶಿವರಾಮ್ ಕಾರಂತ್ ಬಡಾವಣೆಯಲ್ಲಿ ಸಾರ್ವಜನಿಕರಿಗೆ ನಿವೇಶನ ಹಂಚಿಕೆ ಮಾಡುವ ಸಲುವಾಗಿ ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆಯನ್ನು ಹೊರಡಿಸಿ ಸಂದರ್ಭದಲ್ಲಿ ಸದರಿ ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆಗೆ ಅನುಸಾರವಾಗಿ ತಾವು ನಿವೇಶನಕ್ಕಾಗಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದಲ್ಲಿ ತಮ್ಮ ಅರ್ಜಿಯನ್ನು ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲಿಸಿ ಅಗತ್ಯ ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗುವುದೆಂಬ ಅಂಶವನ್ನು ಹಾಗೂ ಉಲ್ಲೇಖದಲ್ಲಿ ಮೆಲಾಡ್ಸ್ there was a writ appeal that was pending, my lords, which has now been disposed of, allowing the BDA to make allotments, my lords. So as
You have to do two things. First, put a name in the lot.
yes, that has been carried out. My lords, we will correspond with them and then tell them.
There is an order that you will change his name. Put a name.
My lords,
You don't have a copy of the order?
Changing of the name, my lords, that has been carried out, my lords. That is my instruction. Change of the name from her deceased spouse name to as that of the complainant has been carried out, my lords. As regards the allotment of
That's
the
not what
site.
your memo is saying.
Sorry,
The memo is saying Counsel for the accused would have placed on record endorsement bearing confirming that the name of complainant would be replaced instead of that of her husband if the requisite documents are provided for further processing.
In the records, my lords, meaning to say her Aadhaar card, her PAN card, all that is what we would be asking, my lords, and it has been dispatched today, my lords. I received it only now. But I have been instructed, my lords, that the name would be changed, my lords, that the name would be changed. The changes would be carried out in all the registry and.
That's not the order. The order says change a name. Take from the cause title of the petition and change a name. You don't require anything more. It's a direct order.
Please, I'll instruct them, my lords, to
And
change.
then second is process the allotment. Then if you require some documents, you can ask for that purpose.
Yes. If my lordship can kindly grant me 4 weeks time, my lords, because now we have been permitted to allot sites in this particular layout, my lords.
Learned counsel appearing for BDA 6, 4 weeks time to report compliance.
The 9th of October. Number 20.
What is sought for, my lords, is one complaint of the order at page 11. It starts at page 11. And, my lords, operative portion, my lordships will see at page 14. The
BDA, you'll have to be in here also. Please. You're also against BDA.
Item 20.
Serial number 20. BDA is
I'll take instructions on Monday, my lords.
20 learned counsel appearing for Karthikeyan, learned counsel for the BDA 6 time to take instructions. List. Just give him a copy. He may not be having.
I'll sir.
9th of October. Number 21.
Could there be an earlier possible date?
Yes.
Could there be any earlier possible?
Won't come otherwise. Let it.
For 21.
With your lordship's permission, we file the compliance affidavit.
I will go through it, your lordship. Kindly start accommodation.
Now, with respect to the direction not to interfere with the CBSE schools, I have filed in the affidavit that there is no interference with respect to the CBSE school. And the other relief with respect to the reimbursement of the RT fund, that also has been paid in 2 installments dated 11/3/26 and 25/3/26, stated at para 7 of the affidavit.
Yes.
Lordship, well, kindly 2 days accommodation, your lordship. I will go through.
So he says they've already
Lordship,
paid on
as-
25th of March and 11th of March.
Lordship, as per the annexure AJ, your lordship, representation is to consider my representation, your lordship. I have already submitted before the accused department, your lordship. That is not at
No, what if you
till
agree?
day, your lordship.
If you are aggrieved by this, they'll have.
Your lordship,
You'll
kindly
have to
have
take some
have it
steps.
on tomorrow, your lordship.
All right, have it.
Tomorrow, your lordship.
Seal number 22.
They seek for 2 days accommodation, my lords. The order is being passed through the course of the day, my lords. It will be complied, my lords. I'll file it. my lords.
Council appearing for the accused.
Next week or
2 week, 2 further days to pass to report compliance. List on, put it on Friday.
31st July.
Obliged.
Number 23. Sir, SK Mithun, commercial affair.
None appears for the parties. Mr. Justice re-notify.
Please. 4th of November. 24 urgent.
My lords, I appear for the appellant. I have not moved for an examination. Let's see. The respondent seems to have sought the respondent.
He said he told you.
It's a very short point, my lord.
He said he had no objection. He said you had no objection.
No. He did not inform me at all. I've been waiting from the morning.
He asked you, have you informed him? You said he has no objection.
I'm sorry, there is absolutely. I was here, from the morning.
All right, you tell us. Tell us.
Please. The short point in this case is the entire finding or the reasoning of the trial court is that an agreement between the appellant and the respondent is invalid and unenforceable.
Yes.
As such, it is against public policy.
Yes.
The arbitrator has passed an award saying that the agreement is annulled on a different finding, that the respondent has failed to perform the obligations under the agreement.
Yes.
The trial court's only observation is that since the agreement itself is invalid, unenforceable, it is against public policy, there was no arbitrable dispute at all. Therefore, the question of going into the willingness or unwillingness or readiness or otherwise shall not arise. As such, it has set aside the award which has annulled the agreement. The entire finding is, that the agreement is invalid.
All right.
It's a short point.
What point?
That
the agreement is invalid.
Millards, I will just take your lordship's kind attention. Your lordship may kindly turn to page number.
That is point number 2. Point number 2 is whether the agreement is invalid against public policy.
It's not valid and against public policy, which is exactly the award the arbitrator has passed. Your lordship would get the same at page number.
Let's see the reasoning.
37, Millards. Ink page 37.
The award starts at page 66. No?
Millards.
Your award
starts with page 66.
Is at page 66.
This is a decree, Millards. In page 66 is the decree.
Where is your award in this?
The award is at, Lordship would get it at 78 it starts.
Yes.
88 is the award. The claim petition is allowed. It is ordered that Exhibit P6, the Management Development Agreement dated so and so, stands annulled as prayed for on a different finding. But the trial court says that the agreement itself is invalid. Therefore, no less I am setting aside the award. The findings or the reasoning of the trial court is not under challenge by both the parties. The natural consequence should be to annul the agreement.
You are not aggrieved by the award.
No.
Your
And what
Lordship,
are you aggrieved by?
In fact, the respondent has agreed by the award. The award was in my favor. I filed the claim petition.
No, so why are you filing
See, in
this
this,
30?
by passing an order by the trial court, it has set aside the award. By holding that, the award should go.
But according to you, the reasoning is that the whole agreement is against public policy.
Right, Williams.
So what difference does it make to you?
It has set aside the award where, no, like, see, it has created a situation where subsequent to or during the pendency of the arbitration, they have executed a sale agreement in favor of a third party at the back of mind.
Therefore, the agreement is set aside.
The
entire agreement
in respect of that, there is a suit pending where they are taking a contention that, like, in view of this setting aside of the award, that agreement is valid.
No, that you'll have to only show. We don't know what they're saying, but the reasoning is.
so let
I understand. In fact, I filed an amendment petition. Amendment petition was, like, rejected.
let them challenge the agreement and come, Your Lordship.
Why? The agreement has been set aside. Let's see the reasoning in point 2. What is in the judgment which is in the appeal?
Millards.
Point 2 is whether the agreement is against public policy.
Right, Millards. There is a finding. However, it goes ahead and then
Let's see the
it
finding.
says, Millards.
Let's see the finding.
The reasoning, there are 3 aspects the trial court has considered. One is the limitation as to whether 34 petition can be maintainable. That goes till 50, in page 53. Lordship would get the findings of the trial court as far as point number 2 is concerned from 53. Point 2 and point 2, 3 and 4. These are 3 points taken together for common consideration to avoid repetition. It is not in dispute that the plaintiff and the defendant have entered into a management development agreement dated so and so in respect of land bearing so and so for the purpose of formation of comprehensive layout after getting land was denotified from acquisition. I'll just skip this portion. This was briefly the background of the case is, Millards. There was a management development agreement executed between 2 parties where the property was already under acquisition by the BD. He has undertaken to initiate the process for denotification and all. The Lordship would get, these are admitted facts. Your Lordship may kindly turn to page number,
Yes.
page 56.
Yes.
Para 28.
Para 28.
20. The counsel for the plaintiff also. Plaintiff is the respondent herein who challenged the arbitral award before the trial court under 34. The counsel for the plaintiff also submits that as on the date of referring of the matter of the arbitration proceedings, the subject matter of the dispute was not capable of settlement by the arbitrator. See, it just goes on. The next para, it is further argued that as on the next parameters, it is further argued that on the date of execution of the agreement, the lands in dispute were already acquired by BDA and West with it. Any agreement during the acquisition proceedings is illegal, unenforceable, and it is against public policy. It just refers to case laws in this regard and repeatedly says that the agreement is invalid and unenforceable. As such, the arbitrator ought not to have gone into the question of whether readiness, willingness, any aspects or any terms, whether the party has fulfilled or otherwise. There is no arbitrable dispute. As such, like the arbitration award shall not sustain.
No, it doesn't seem to. It says the award is against public policy.
That's I see. It says the agreement is against public policy.
And therefore, the award is against public policy.
Therefore, I see he ought not to have gone into the question of readiness or willingness or obligations of either of the parties in the arbitral proceedings.
What are you saying then? According to you, the agreement is legal and binding.
As far as the annulment of the agreement should stay. The arbitrator
Are you contesting the finding that this is against, the agreement was against public policy and was unenforceable?
I concede that this agreement is invalid and unenforceable. I am not quarreling on that.
Then what is wrong
But
with
ultimately,
then
if
how will
you
the
want to
awards
set aside,
then how will the award stay?
Ultimately, the final award is for annulment. The arbitrator.
But on a
has
different
annulled.
ground. But on a different ground.
On a different ground.
So an annulment is on a different ground. Here the court comes to the conclusion that the agreement is invalid, which you agree.
Yes, ma'am.
And the logical sequitur to that is that even the arbitration agreement is invalid. Then how will your award stay?
The arbitrator's final award is for annulment. That is where the crux
We
is.
followed your point that it is against annulment. We're only asking you, is the finding of the learned commercial court or learned district court that this agreement is unenforceable? You agree with that view?
Yes.
So if the agreement is against public policy and is unenforceable, then how will the award on any other ground sustain?
Ultimately, the award is, has an.
But on a different ground, no.
I understand.
And today an arbitral tribunal may come to the conclusion, no, he is in breach of the agreement and therefore it should be annulled. The court comes to the conclusion that this agreement itself is unenforceable. You say, yes, it is unenforceable, but the award should sustain. So you please tell us, how will the award sustain when you yourself are saying that the agreement is not sustainable?
Yes, it has given a confusion where on the basis of this management development agreement, he has executed a sale agreement in respect of the entire property.
No, please don't go in reverse engine by finding out what he is doing and therefore what is right or wrong. Let us go the forward way. You've challenged the finding of the district court that this award is setting aside the award under section 34 on the ground that your agreement is unenforceable. Now you start by saying, is the finding incorrect of the learned thing? You say it's correct.
Finding is incorrect. Question.
Finding is correct, not correct.
Finding is incorrect.
Correct. Then in the finding, why would the award not be set aside?
If your lordship gives a shorter possible date, we have engaged the senior counsels and services. Only a short point as far as the only
just a learned counsel appearing for the appellant states that the agreement, management and the management and development agreement. No, just like the learned district court had
Your Lordship, without granting stay, the
concluded
case
that
may be
the
adjourned, Your Lordship.
management and the development agreement was invalid as it was against public policy. Full stop. Learned counsel appearing for the appellant submits that does not challenge the said finding. He submits that notwithstanding the said finding, the court could not have set aside the arbitral award since the arbitral award had declared the management and development agreement as cancelled on a different ground. Full stop. He seeks time to address submissions, further submissions in this term.
Shorter possibility.
Let's just put a short date on this.
16 September.
I'll put this on Friday. We'll be ready by Friday. Short question.
31/7. December 25.
Yes.
What respondent is the subscriber of the chit, sir. But sir, the total subscription is for 1,50,00,000 lakhs, sir, which was due. We have raised the dispute for recovery of 1,25,00,000 lakhs, my lord, sir. In the meantime, there were some amounts which have not been paid by him, for which he has issued the checks, sir. Separate check bound cases was also initiated against him.
Yes.
My lord, sir, in the check bound proceedings, my lord, sir, my lordships may kindly peruse at page number 225, my lords. In the appeal, in the criminal appeal which has been filed by us before this Honorable Court has specifically held that page number 227 is the relevant portion, paragraph number 2.
Yes.
May I read?
Yes.
The appellant has raised disputes against the respondent in dispute number 233 to 240 of 1112 on the file of register of checks for realization of the amount, including the one payable under the 4 dishonored checks, in the respects of which the complaints as above were presented, and the respondent was prosecuted for the offence punishable under section 138 of NI Act. In the said proceedings pending before the register of checks, the respondent has paid by way of demand draft rupees 36,50,000 to the appellant. The said amount covers the amount payable in respect of the dishonored checks in question. In view of the aforesaid payment and the pendency of the said dispute, it is necessary for the appellant to process. It is unnecessary for the appellants to prosecute those appeals, and the same shall disposed of. However, it is made it clear that in the list between the parties, which is subject matter of the dispute number 233 to 240 of 1112, shall be adjudicated and decided in accordance with law. The impugned common judgment would not stand in the way of parties seeking adjudication of the said disputes before the register of checks. Now, my lord, sir, the amount is 36,50,000. Which is the amount payable towards the check bounce cases. My lord, sir, here what has happened? One fine day, forcefully signatures were obtained in the compromise petition, and the respondent number 4 filed a compromise petition before the registrar. My lord, that compromise petition was challenged by us well within 7 days. That has been considered, and the compromise order has been set aside, which has been challenged by the respondents before the joint registrar. There also the order has been confirmed. As against this, the writ petition has been filed. In the writ petition, my lord, sir, the honorable single judge has held that once the compromise has been entered into, it closes the matter, you cannot reopen. My lords, my respectful submission is that, my lords, the compromise what we have entered into, it is only with respect to the 36 lakhs which has been payable before the payable with respect to the check amount. The total amount payable by the respondent is, as on the date of when we raised the dispute, is 1,25,00,000. 36 lakhs was only adjusted towards the check amount. That with respect to the remaining amount is that, my lords, we are contesting the matter. We have well within time we have filed the application for recall of the compromise petition that has been considered. But the honorable learned single judge has said that it is only since it is pertaining to the entire amount, he cannot reopen the compromise. We cannot reopen the compromise petition. That's the order. The relevant portion of the order is at, my lords, at page number 26, in page number 26, paragraph number 13, my lords.
So what is your genesis of 1,25,00,000?
My lord?
Why do you say that 1,25,00,000?
Yes, he has subscribed for 8 checks, sir. Each check pertaining to rupees 25 lakhs, my lords.
And your compromise is regarding how many checks?
4 checks. 4 checks amounting to rupees 36,50,000.
No, chits. Yes, according to you, is subscribed to 8 chits.
8 chits, sir. Well, all the 8 cases were going together, my lord, sir. The case numbers are 230 to 241.
Yes.
all the 8 cases were jointly going together, and compromise has been, the application was filed with respect to all the cases. Annexure R1, page 222 is the application filed by Milots.
Let's see the order of 29 January 2016.
29 January 2016.
That would record your compromise.
Please, Milots.
Or the joint memo. Let us see a joint memo.
Joint memo, it is at Milots, sir.
Page 165.
165.
It's recorded in the order sheet, right?
Translated copies of 165. The petitioner and the respondents have submitted the joint memo and mutually agreed to settle the outstanding amount due to the petitioner in the court through a single payment through DD and have signed the joint memo. The petitioner has agreed to sign the joint memo and has agreed to dismiss the pending case against the respondent by receiving 36,50,000. The petitioner and the respondents 1 and 2 have appeared and made the statements. The petitioner has agreed to this and the respondents have received the 36,50,000 wide DD dated. So in this case, since the respondent have agreed to withdraw all the cases filed against them.
So you agreed to withdraw all cases filed against in various courts.
Malot, sir, my application.
And it is concluded not appropriate to proceed with the
Malot,
case
sir.
and dismiss cases number 2.
Prior to this itself, Malot, sir, the order before this Amba court was passed in criminal appeal. Prior to this order.
No, but wherever it will be pending somewhere. No? All your cases are withdrawn. And these are particularly cases number 233 to 240.
Please, Malot, sir.
If this case doesn't survive, will you or any?
Malot?
If 233 to 240 do not survive, then
the same cases, Malot, my application at page number 222 may kindly be seen, Malot.
220?
222. This is within 7 days I filed the application. For the reasons stated in the accompanying affidavit, this Amba Court authority may recall the compromise memo filed on 29/1/2016, which is unfair, and the same was done by bringing muzzlemen and due to threat, the disputant was forced to sign the papers in the interest of justice and equity. In paragraph number 2 of my affidavit at page number 223, Malot, I submit that I have demanded the opponents to pay the outstanding check amount on several occasions. After several demands, the opponent number 1 on 15/10.
No, but did you tender your money? Did you tender back your 36 lakhs?
In the check, with respect to those check bounce cases, they have paid the money.
No, will you give the 36 lakhs back? If you say your compromise was affected by coercion, first thing you have to do is to go and say, please take the.
No, in 138 matter, it has been specifically stated that has been adjusted towards the check amount.
You can't modify this as
that has
compromise statement in this manner.
No, my lord, sir, my lordships may kindly see once again the order passed in the criminal appeal, my lords, which is at page number 225. The said amount at page number 228, the said amount covers the amount payable in respect of the dishonored checks in question.
Yeah, of course it covers that amount, but it also covers more than, it doesn't say that this is only those and the others are still live.
But even in the last paragraph also, it has been stated that the dispute, whatever the pending before the parties, that will go on with respect to the remaining amount.
This order is passed on which date?
It is passed on, my lords, 9 February 2016, my lords.
And your compromise is?
Compromise was entered on, my lords, 29/1/2016. After this was clarified. This was clarified in the criminal appeal. This compromise, what has been entered, that has been clarified in the criminal appeal.
Same numbers. All right. Yes. Will be defended by those private parties. Nobody's
Private
appearing for them.
parties. I appear for the authority who's passed the order, different registrar of chit funds. Contesting parties respond number one.
What about respondent one?
Respondent number one, my lords.
Shyam Shiv Prakash.
Somebody appearing for him. None appears for respondent number one. In the interest of justice, re-notify.
September. December 26.
Lords, the learned my case is currently held up in court hall, another court hall, my lords.
Last occasion, my lord, the party
The party person had made submission.
submission stating that the state authorities must upload the data of the students who have dropped out and the students who have been brought to the mainstream. They are willing to upload, my lord. That is the only concern she expressed.
No,
on
no, she
last
said 5-7. Mr. Fanindra was to address and say they are included. That's all that was there.
The data we will upload, my lord. There is a series of program which is an ongoing process, my lord. Every year we collect the data, my lord. For the last 3 years, in fact, I have collected the data of the students who have been identified and brought to the mainstream. And we are willing to upload it, my lord, for the purpose of transparency and information in the official website. We are willing to upload that information. That is a grievance, my lord, that these data are not available.
No, that is only one.
Please.
It's only one of our concerns.
Please.
Other concerns as well. All right. We'll put it next week.
Please, my lords.
A request for adjournment is made on behalf of the learned amicus curiae who's been held up in another court. List down.
August.
She's on a different course.
Number 27.
And for the respondent number 7, this case number.
Who's for the petitioner?
Mr. M.R. Vijay Kumar.
And for the respondent number 7 minutes.
None appears for the petitioner list.
11th November. Is number 28.
Some time, my lord.
It's a 2024 matter, my lords. On earlier 2 occasions, it gone out. And there is a very limited question. It is a saved application. Revenue NOC by the Deputy Commissioner has given. And Forest NOC was also given earlier to 12/8/2016. and the matter ought to have been placed before the state government, whereas it was placed before the task force committee, and this honorable court was pleased to.
Learned Counsel, Learned AGA seeks further time to obtain instructions. Final opportunity is granted to do so.
A short week's time or 10 days time, I can.
Just give a list.
24 September.
Apply.
India, August month, my lords.
August is really bad.
December 29. Working plan, my lord, is under progress. This is regarding that working plan, my lord, is still
Yes.
under progress, my lord. We might require some time in this matter. My lord.
How much time would you want?
Any date after 4 weeks, my lord, because we have to approach thereafter the MOEF, my lord.
Yes.
My lord, as on today, my lord, there is an interim order in operation, my lord. We have also gone on record stating that we will not carry out any activity with vision, my lord. They are bound to that, my lord.
Lord, may make one submission. On 15/6/26, my lord, the Honorable Court was pleased to pass an order that, my lord, the proposal has been sent to the MOF. Lord, my understanding is that, my lord, I just verified it has not been sent at all.
So, my lord,
So
my
that has to be
submission was that
clarified.
It would be sent, my lord.
It would be sent, my lord. That should be clarified.
Lords, may I make a submission, my lords?
I have an interim order.
No, my lords. My lords, there is an allowance of work that's been permitted by this court, my lords, on no merits whatsoever, my lords. My lords, if I may be allowed to make a submission, my lords.
One second, this is an order of?
My lords, order dated 3rd of March, my lords.
15th June, my lord.
15/6/26.
No, but we've also recorded, if you see the order of 13 January. We've recorded your statement.
The interim order was granted based on a statement, my lord, initially. That came to be modified subsequently
That's
because
right.
we moved.
That's right. So there is a.
There is a clarity, my lord. The statement that they have made is that there is no proposal pending. with
That's
them.
right. That's what they said. State said no proposal is received
Please,
regarding the
Yes.
project in
That
question.
is the position today, my lord.
That is the position today, my lord, but the submission was recorded that it has been sent, therefore I.
My lords, I have documents to prove that the proposal was sent. It was rejected and they were re-asked to apply for the proposal again, my lords.
That submission I made on the last occasion, that they have returned the submission, and so the revised proposal will be sent.
My lords, it's,
It has not been sent.
my lords, may I, lords?
It's all right, my lord. Let him finish. my
Shanti
lord.
Bhushan, then DSG states that the order dated 15 June 2026 records the submission of the, points out that the order records the submission of the additional government advocate that a proposal has been sent to Ministry of Environment and Forest seeking permission for carrying out non-forest activities. These states said no such proposal has been sent or received by the ministry. The learned AGA submits also concedes that the proposal has not been sent as yet. And his statement made on 15/6/2026 was not accurate.
My lords, on 3rd, my lords, if I may read order of my lords dated 3rd of March. Lords, learned advocate general appearing for the state submits that all works at the site are stopped pursuant to the interim order granted on 13/1/2026. My lords, in their wisdom, granted me a stay on all works. Now, my lords, submission is that all works are stopped pursuant to the interim order, my lords. My lords, the infirmity here is that there was no permission. So at the pretext, there was no permission. They could not have initiated the work at all.
No, non-forest they could not have. Forest, for non-forest purpose they haven't, but they're saying there is some work.
My lords,
which
there
they
is
can
no
carry out as a part of the forest.
The second infirmity with my lord's order is, my lords,
The lordship
that
has
there
made
is
it
no
very clear in.
there is no distinction that can be created. The allowance and the budget the budget is a wrong linguistic term, my lords. These are funds that are allotted. The funds are allotted on challenge based, my lords. My lords, that essentially means if there was any other project that had permission, if there was any other project by any other state, they would be entitled to these funds. Submission that these are budgets is an erroneous submission, my lords. Now, second, my lords, second para of the order, my lords. Well, I could, if I may.
Yes.
In the aforesaid circumstances, we consider it apposite to modify the interim order to permit certain developments. My lords, it is one to stay the works, my lords, but it's entirely different, my lords, to allow a work, my lords. This order essentially creates a permissibility for the state to carry out works for which they have no permission, my lords. My lords, there is a statutory mandate. My lords, if I may take my lords to.
If you see paragraph 1, they say there's some works which would not require diversion of forest land.
There is no distinction, my lords. The permission for the works or for the DPR should have been sought on the entire project. It cannot be that an order allows construction of an entrance plaza and another order allows, it cannot be, my lords. The severability cannot be.
They have also argued that there are a large number of otherwise visitors there and they can use the facilities. So in either event, even if the project does not go through,
my lords, it's a forest area.
That as far
There
as
is a
facilities are
statutory
concerned,
mandate.
they can do that.
My lords, if my lords may peruse page 77 of the objections filed, my lords. My lords, my proposition is that the permissibility of work by this order, my lords, has rendered my entire cause before my lords futile. That's my contention, if my lords may consider my submission. Page 77, my lords.
Just take down. The Leonard AGS 6 further adjournment states that the working plans are yet to be submitted. I will request this one. Listed on, how much time do you want?
Anytime after 4 weeks.
Weeks, put it up.
My lords, the plan and the project will not stand, cannot stand muster of basic judicial review, my lords.
No.
If given audience, I shall establish, my lords.
3rd September. Number 30.
My lords, meantime, my lords, there is no monitoring that's happening. I have my lords, I have photographs of trees and non-forest activities being carried out at the site.
Lord, I have filed an affidavit along with that the photographs of the present status, my lord. And we will produce after completion of the work, the photographs post completion of the work also we have undertaken to produce before the court.
It's on the affidavit, my lords.
It's filed on 24th March.
My lords, on
this petition piecemeal.
My lords, on the affidavit, my lords. My lords, there is a precedent of this honorable court of the same bench, my lords, that declaration of deemed forest, the affidavit is filed before the honorable Supreme Court, my lords. Any diversions, the permission and the leave has to be sought from honorable Supreme Court, my lords.
There's no difficulty on that.
I shall produce that as well in the. If my lords, if an audit of work as to what
we will hear your petition when we take it up. We are just adjourning it. Interim orders, we've heard you on interim orders before and we've passed interim.
No, my lords, I was not heard on my interim order, my lords.
No. Call the next item.
My lords, may have it, please.
I appear for the petition of Lord. 30 and 34 are identical, Lord. In pursuance of the order dated 16/10/25, we have filed our written submissions. I may be permitted to file, my lord, the revised written submission. It is ready. I'll file it tomorrow, my lord. Your last may kindly have it day after tomorrow, along with the citation. Because in the earlier submission, I have not enclosed citations.
All right. Good day after tomorrow.
I may be permitted to file revised.
Learned counsel appearing for the petitioner seeks to file revised written submissions. Let the same be filed within the period of 1 week from today. List. Put it after the week. 30 and 34.
10th of August. December 31.
So this matter pertains to levy of environment compensation,
Yes.
wherein your lordship pursuant to Delhi Supreme Court judgment had granted a stay.
Yes.
May I be please permitted to place on record the clarification order issued in the same matter, your lordship, by Supreme Court? Page number 3, your lordship. They have noted that the above direction should not be understood to mean that the regulators, being the Pollution Control Board, cannot proceed to impose and collect the compensatory environment damage in the absence of subordinate legislation.
Yes. Who's appearing for the?
Mr. Angad Kamath.
Only coercive steps have been stopped now.
Please, your lordship, so the enforcement of the environment compensation has also been stopped through the interim order, your lordship.
None appears for the. None appears for the petitioner. Learned counsel appearing for Karnataka State Pollution Orders referred to and dated 21/5/2026, passed by the Supreme Court clarifying the directions issued in Delhi Pollution Control Committee versus Lodi Property Co. Limited, Poland 2025 SCC online SC 1601. Full stop. The said order is clarified. As 21/5/2026 passed in civil appeal number 757-760/2013, caption DPCC versus Union of India through Secretary. The said order clarifies the directions issued by the Supreme Court in Delhi Pollution Control Committee versus Lodi Property Co. Limited. The Supreme Court had referred to the directions in paragraph 39, bracket C of the said decision, and it clarified as under. Let's say it would. This court had passed an interim order on dated 14/11/2025, directing that no coercive steps be taken for recovery of the environmental compensation on the basis of the directions issued on paragraph 39, bracket C of Delhi Pollution Control Committee versus Lodi Property Co. Limited Supra. Since the said directions have been since clarified, the interim order passed on 14/11/2025 stands vacated. List for further consideration on that. Let's copy this.
11 November. Number 32.
The petitioner, being aggrieved by Annexure A, a work order, petitioners are before this court. The grievance of the petitioners are that while the work order, a Rangamandira, open theatre, is not directed to be put up by leaving about 16 feet into 300 feet between the compound wall and that open theatre. Initially, earlier, by way of a writ petition, the very same petitioners, except the petition number 3, had approached this honorable court. The public interest litigation came to be allowed. Page number 40, Annexure C. Just to protect the government field,
yes,
wherein several government institutions running from Anganwadi to colleges are there. About 36 kunta is the only place available for them to play. Page 40 is the order. But operative portion, the relevant portion is at page 46, para number 3 onwards. May I just read?
Yes.
Page 46, para 3. The subject land bin has been depicted in Annexure A4, a perusal of which shows that an endeavor has been made to carve out a road within the and across the property of the composite college and school. The state government has taken the stand that no permission was granted for the construction of the road within the property of the composite government pre-university college or for the construction of a wall for any purpose whatsoever. There is no challenge to the ownership and possession of the composite pre-university college. By recording this, the writ petition came to be allowed. Relevant portion, paragraph number 5. In these circumstances, writ petition is allowed. Respondent number 9, the Deputy Commissioner Ramnagara Taluk District, Ramnagara, is directed to take immediate and necessary steps for the removal of wall within the property of the composite pre-university college, BDC, needful to be done within 4 weeks from today. Thereafter, a compound wall was annexed. By breaking open the compound wall, the residents of a nearby colony, they were making way inside the school field. Now, to make it as a final thing, now this work order is issued by leaving 16 feet into 300 feet between the compound wall and the Rangamandira. There is already a Rangamandira inside the premises. A second open theatre is being constructed just to leave this space as a access road to the nearby colony. One of the resident of a colony, he is elected as the corporator of the 10th respondent corporation. Yes. He is behind all this. And a videograph my lord, is also produced, wherein my lord, the member of my lord, the Legislative Assembly, he is openly saying, my lord, that if we do like this, no court will stop us from doing this. And one of the officials, my lord, he has also, my lord, a recorded conversation, typed copy, my lord, is produced by me. My lord, I'll just show it. My lord. Annexure G, my lord, page 66. He is also clearly saying, my lord, that they are trying to leave open, my lord, my lord, access road to the nearby, my lord, the colony residents. My lord. In that view of the matter, my lord, the petitioner, my lord, are again, my lord, constrained to approach this.
Instructions this morning, if my lord could grant me 2 weeks, my lord, I'll file this statement.
Let's see the map.
Please, Annexure K, my lord, Annexure, page 73. There are access roads, my lord, from either direction. This black portion, my lord, this is where, my lord, they are trying to put up the con.
Where you see it,
Page 73.
75C.
My lord, Annexure K, my lord.
Yes.
Please, this portion, my lord, this black mark portion. That is the compound wall. By leaving about 16 feet into 300 feet, my lord, they are constructing.
No, so the school is there. There is a gate open for the passage open for the school.
Yeah, yeah, that gate is open, my lord. That is only, my lord, for the school
That's
and
right.
college purpose,
That's right.
not for the nearby residents, my lord. It is fully covered by the compound wall. This gate is open, my lord, for the school purpose only, my lord, school and college.
There are two schools. One is a government school. One is
No, that is this is, my lord, separate. This is not
Basaveshwara school.
by way of a compound wall. This is separated. That is Basaveshwara school, not that is another school. That's a private school.
So this path is being made,
Inside the government school, my lord.
and it is leading to the.
That is leading to the gate, my lord.
My lord, just by way of a preliminary glance, my lord. My lord, the photographs.
Let's show this.
The open theater is in the second page, my lord.
Yes.
The open theater,
Yes.
my lord, is in the second page of the photographs that I have
Yes.
produced before, my lord. It's for the children's cultural activities, my lord. I'll file my statement, my lord. I've just received it.
His case is that once you open this gate, this road,
Hmm.
it's a thoroughfare between the Bidadi main road, railway station, and the crossroad behind.
My lord, I'll justify that.
Then it is 6. Time to file its statement of objections. No, in your map, where is this open theatre?
There is already one it is not to the other side now. One that is being constructed here.
No, this one which they have said is where, in your map where?
Annexure K, my lord. The newly
Okay, where does it reflect this open
newly
theatre?
constructed, my lord, is this portion, my lord, this black portion.
No, that's only a road access.
No, there, my lord, they are constructing now.
You have to show.
Next to the compound wall.
I'll give him a copy.
Yes, my lord, I'll file my objections. on
This.
Second November.
Call the password.
Please.
Resolution.
So, list number 2, seal number 30.
Yes, I'm the petition. I am submitting environmental petition.
You are in which petition?
I'm the government.
No, which petition are you appearing in? Which is the petition are you appearing in?
Serial number 30, I believe, my lords. It says Mahendra Kumar Mitra. He was party in person previously, my lords. I think he's filed the work.
We are taking up 30.3 WP 25515.
Yes, my lord.
Yes.
My lord, yesterday, when the matter stood over, my lord, I was seeking to refer to Annexure J, page 183, report of Justice Nagmohan Das Commission, submitted on 1st August 2025. To show that the findings, there are two reports which do not gel with each other. I'll just point out one sentence, my lords, from page 191. Two sentences, the three-line paragraph, my lords. Could my lords have page? After the tabular column, this is what the finding, my lords, insofar the progress of the scheduled castes is concerned. The performance of scheduled castes in the field of literacy is excellent. Out of 101 castes, 83 have a literary rate higher than 80%. That is, the literacy rate of 83 castes is higher than the state level average literacy rate. To say, my lords, after these many years, there is no progress. This falsifies the claim. Then, my lords, the report also refers to the various employment details that I have placed before, my lords, the 31/3/2023 figures given by the government department itself. Therefore, I would not like to trouble my lords with all those things. Now, my lords,
yes.
Yes. My lords, I referred to Lordship Justice His Lord's Ashok Bhushan's view in Jayesh Lakshman Rao Patil, particularly with reference to, my lords, the adequacy of representation and all that. A few more paragraphs from that judgment, my lords. If my lords would kindly take volume 2 at the 844 page. That is where the judgment of the Supreme Court in Jayesh Lakshman Rao Patil commences. Then if 50% ceiling is breached, what would be the consequence? Is very graphically dealt with. Before I go to Lordship Justice Ashok Bhushan's view, concurring view of Lordship Justice Ravindra Bhatt, it is at page 919, para 33 minutes.
Yes.
Upon examination of the issue from this perspective, the ceiling of 50% with the extraordinary circumstances exception is the just balance, what is termed as Goldilocks solution. The solution containing the right balance that allows the state sufficient latitude to ensure meaningful affirmative action to those who deserve it, and at the same time ensures that essential content of equality and its injunction not to discriminate on the various prescribed grounds, caste, religion, sex, place of residence is retained. This court in M. Nagaraj versus Union of India observed that a numerical benchmark is the surest immunity against charges of discrimination. To dilute the 50% benchmark further would be to effectively destroy the guarantee of equality, especially the right not to be discriminated against on the grounds of caste. Footnote, my lords, my kind of footnote 45 there. What is Goldilocks solution is, the difficulty then is finding the Goldilocks solution, not too large, not too small, but just right. That is how 50% ceiling is described. Then, my lords, at para 34, next page, the Lordship says that there is no, rejects the argument seeking reference of reconsideration of Indira Sani. Then, lords, to page para 384, 386, my lords, at page 1060. Rest of the paragraphs I have taken, my lords, in between there. 386, my lords, page 1060.
Yes. Yes.
The judgment of Indira Sani has been followed by this court in a number of cases, including at least the following 4 constitution benches: Postgraduate Institute of Medical Education, M. Nagaraj, K. Krishnamurthy, which judgment, though was considering reservation under 243 and 247, has applied 50% ceiling as laid down in Balaji. That is not even where proportional representation is applicable, 50% ceiling is sacrosanct. The Constitution Bench judgment of this court in Chepro, the Leela Prasad Rao reiterated the principle as referred and reiterated that outer limit is 50% as specified in Indira Sani's case. This was the case of teachers in scheduled areas where 100% reservation was provided. Then moving on, my lords, para 391 at page 1061, Dr. Ambedkar's speech is reproduced in the Constituent Assembly.
If the honorable members will bear these facts in mind, the three principles we have to reconcile, they will see that no better formula could be produced than the one that is embodied in clause 3 of Article 10 of the Constitution. They will find that the view of those who believe and hold that there shall be equality of opportunity has been embodied in clause 1 of Article 10. It is a generic principle. At the same time, as I said, we have to reconcile this formula with the demands made by certain communities that the administration, which has now, for historical reasons, been controlled by one community or a few communities, that situation should disappear, and the others also must have an opportunity of getting into the public services. Supposing, for instance, we were to concede in full the demand of those communities who have not been so far employed in the public services to the fullest extent, what would really happen is we shall be completely destroying the first proposition upon which we are all agreed, namely that there should be an equality of opportunity. Let me give an illustration. Supposing, for instance, reservations were made for a community or a collection of communities, the total of which came to something like 70% of the total posts under the state, and only 30% are retained as the unreserved. Could anybody say that the reservation of 30% as open to general competition would be satisfactory from the point of view of giving effect to the first principle, namely that there shall be equality of opportunity? It cannot be in my judgment. Therefore, the seats to be reserved, if the reservation is to be consistent with clause 1 of Article 10, must be confined to a minorities of seats. It is then only that first principle could find its place and the Constitution in the Constitution and effective in operation. The above views of Dr. Ambedkar expressed in the Constituent Assembly for the balancing draft Article 10.1 and 10.3 equivalent to Article 16 and 16.4 have been referred to and relied on by this court in Indira Sani as well as in other cases. Remember paragraph 397 at page 1063. The 50% rule spoken of in Balaji and affirmed in Indira Sani is to fulfill the objective of equality as engramped in Article 14, of which Articles 15 and 16 are facets. Indira Gandhi itself gives answer to the question. Rest of it, they refer to para 807, held that what is more reasonable than to say that reservation of clause 4 shall not exceed 50% of the appointment. 50% has been found said to be reasonable and is to attain the objective of equality. Para 807 is extracted. Then, my lords, 398. In para 808, BP Jivan Reddy referred to speech of Ambedkar, where he said reservation should be confined to a minority of seats. The expression minority, when translated into figure, the expression less than 50% comes into operation. To change, this is very crucial, para 399, where the Supreme Court says to exceed the 50%, it will be replacing society based on equality into a society based on caste. To change the 50% limit is to have a society which is not founded on equality, but based on caste rule. Democracy is an essential feature of our constitution and part of our basic structure. If the reservation goes above 50% limit, which is reasonable, it will be a slippery slope. The political pressure will make it hardly to reduce the same. Thus, the answer to the question posed is that the percentage of 50% has been arrived at on the principle of reasonability and achieves equality as enshrined by Article 14, of which Article 15 and 16 are facets. Earlier, it was treated as an exception, but now there is 16.4, 15.4. Now there is a Article 15 grants general equality, 15, 16 specified fields. Then, the 406, at page 1066, Lordship Justice Ravindran's view in Ashok Kumar Thakur is reiterated. Of course, my lords, after saying all this, Supreme Court is yet to fix a time frame. That is, my lords, for whatever reason. Because in more than once, number of learned judges have felt that there should be a time frame, but that is elusive as yet. 406, my lords. That is 1066. We recall the observation made by R.V. Ravindran Jay in Ashok Kumar Thakur, wherein his lordship held that any provision of reservation is a temporary crutch. Such crutch by unnecessarily prolonged use should not become a permanent liability. In words of Ravindran Jay, caste has divided this country for ages. It has hampered its growth. To have a casteless society will be a realization of a noble dream. To start with, the effect of reservation may appear to perpetuate caste. The immediate effect of caste-based reservation has been rather unfortunate. In the pre-reservation era, people wanted to get rid of the backward tag, either social or economical. But post-reservation, there is a tendency even among those who are considered as forward to seek the backward tag in the hope of enjoying the benefits of reservation. When more and more people aspire for backwardness instead of forwardness, the country itself stagnates. Be that as it may, reservation as an affirmative action is required only for a limited period to bring forward the society and the socially and educationally backward classes by giving them a gentle supportive push. But if there is no review after a reasonable period and reservation is continued, the country will become a caste-divided society permanently. Instead of developing a united society with diversity, we will end up as a fractured society forever, suspicious of each other. While affirmative discrimination is a road to equality, care should be taken that the road does not become a rut in which the vehicle of progress gets entrenched and stuck. Any provision for reservation is a temporary crutch. Such crutch by unnecessary prolonged should not become a permanent liability. It is significant that Constitution does not specifically prescribe a casteless society nor tries to abolish caste, but by barring discrimination in the name of caste and by providing for affirmative action, the Constitution seeks to remove the difference in status as basis of caste. When the differences in status among the castes are removed, all castes will become equal. That will be a beginning of casteless egalitarian society. Now, the government comes and says that after 73 years of reservation, we have to increase the percentage of reservation. That is something, my lords, which on the face of it runs counter to this view. Then, my lords, para 508 at 1102. What are the parameters of judicial review in these matters? Because one of the contentions raised by the state is that it is a policy matter, it is a legislative policy, and this court has to keep its hands off. But Indira Sani has referred to the judgment of this court in barium chemicals for the scope and reach of judicial scrutiny. We need to refer to the test enunciated in barium chemicals. The Constitution bench in barium chemicals had occasion to consider the expression, if in the opinion of the central government occurring in section 237 of the Companies Act. Hidayatullah Jay laid down that, no doubt, the formation of opinion is subjective, but the existence of circumstances relevant to the inference as the sine qua non for action must be demonstrable. The following observations were made in para 27. No doubt the formation of opinion is subjective, but the existence of circumstances relevant to the inference as the sine qua non for action must be demonstrable. If the action is questioned on the ground that no circumstances leading to an inference of the kind contemplated by the section exists, the action might be exposed to interferences unless the existence of circumstances is made out. As my brother Shirath has put it trenchantly, it is not reasonable to say that the clause permitted government to say that it has formed the opinion on circumstances which it thinks exist. Between thinks exist and exist, there is a sea of difference. Since the existence of circumstances is a condition fundamental to the making of an opinion, the existence of circumstances, if questioned, has to be proved at least prima facie. Sheila Jay, with whom Hidayatullah Jay has agreed, In para 63, write down the following. Therefore, the words reason to believe or in the opinion of do not always lead to the construction that the process of emphasizing reason to believe or the opinion is an altogether subjective process, not lending itself even to a limited scrutiny by the court, that such a reason to believe or opinion was not formed on relevant facts or within the limits, or as Lord Radcliffe and Lord Reed called, the restraints of the statute as an alternative safeguard to rules of natural justice where the function is administrative. Then, my lords, may kindly come to para 513, my lords. The grant of reservation under Article 15.4 or 16.4, either by an executive order or by a state or legislature measures or constitutional measures which are contemplated to fulfill the principle of equality. The measures taken under 15.4 and 16.4 thus can be examined as to whether they violate any constitutional principle, whether they are in conformity with the rights under Article 14, 15 and 16 of the Constitution. The scrutiny of measures taken by the state, either executive or legislative, thus has to pass test of constitutional scrutiny. It is true that the court has to look into the report of the commission or commission with deference, but scrutiny to the extent as to whether any constitutional principle has been violated or any constitutional requirements has not been taken into consideration is fully permissible. As laid down in V. Balram's case, the judicial scrutiny is also permissible as to whether from the material collected by the commission or committee, the conclusion on which the commission has arrived at is permissible or reasonable. Therefore, not only the constitutional test of not breaching 14, 15, 16, but also whether the material was such that a reasonable, rational mind would have come to the conclusion that the state has drawn. Then, my lords, yesterday I have taken, my lords, through the adequacy question, but only that is, my lords, question number 12 at page 1104. Only one paragraph, my lords, at page 565 at 1121, where the Supreme Court said that after 70 years of independence, every segment of the society is presumed to have marched ahead. If anything contrary has to be done, it has to be demonstrated. We have completed more than 70 years of independence. All governments have been making efforts and taking measures for overall development of all classes and communities. There is a presumption, unless rebutted, that all communities and castes have marched towards advancement. This quote, then, my lords, it is Ram Singh. This is because one may legitimately presume progressive advancement of all citizens on every front, social, economic, and educational. Any other view would amount to retrograde governance. Yet, surprisingly, the facts stare at us indicate a governmental affirmation of such negative governance, inasmuch as a decade-old decisions not to treat the Jats as backward, arrive at on due consideration of the existing ground realities, have been reopened in spite of perceptible all-round development of the nation. This is the basic fallacy inherent in the impugned governmental decision that has been challenged in the present proceedings. We also endorse the opinion of Brother S. Ravindra Bhatt on affirmative actions and giving of more and more incentives to realize the Constitution, which undoubtedly is the obligation. We are constrained to observe that when more people aspire for backwardness instead of forwardness, the country itself stagnates and situation is not in accordance with constitutional objectives. Then one of the conclusions of this one, they are at paragraph 688, page 1166, my lords. I take, my lords, only to conclusions 1 to 9. Conclusions 1 to 13, which will be relevant to this to our present issue of reservation. From our foregoing discussion and finding, we arrive at the following conclusions. The greatest common measure of agreement is 6 separate judgments delivered in Indrasani is reservation under Article 16(4) should not exceed 50%. For exceeding reservation beyond 50%, the extraordinary circumstances as indicated in para 810 of BPG1DJ should exist, for which extreme caution is to be exercised. The 50% rule spoken in Balaji and affirmed in Indrasani is to fulfill the objective of equality as engrafted in Article 14, of which Articles 15 and 16 are facets. 50% is reasonable and it is to attain the object of equality. To change the 50% limit is to have a society which is not founded on equality but based on caste rule. We are of the considered opinion that the cap on percentage of reservation as has been laid down by the Constitution Bench in Indrasani is with the object of striking a balance between the rights under Article 15(1) and 15(4) as well as 16(1) and 16(4). The cap on percentage is to achieve principle of equality with the object to strike a balance which cannot be said to be arbitrary and unreasonable. Providing reservation for advancement of any specifically education backward and public service is not the only means or method for improving the welfare of backward class. The state ought to bring other measures, including providing educational facilities to the members of backward class free of cost, giving concession in fee, providing opportunities for skill development to enable the candidates from the backward class to be self-reliant. There can be no quarrel that society changes, law changes, people change, but that does not mean that something which is good and proven to be beneficial in maintaining equality in the society should also be changed in the name of change alone. When the Constitution Bench in Indrasani held that 50% is upper limit of the reservation under Article 16(4), it is the law which is binding under Article 141 to be implemented. You find Constitutional judgment is also fully applicable in reference to 15(4) and the Constitution of it. Then TMAPI is distinguished, where it said that the setting aside of 50% of the 11-judge bench in TMF as was laid down in Stephen case is 50% ceiling in admission in aided minority institutions and has no bearing on the principle of 50% ceiling laid down in Indrasani in respect of reservation. Judgment of TMEFI was in reference to rights of minority under Article 30 and is not relevant for reservation under Article 16(4) and 15(4). The Constitution 81st Amendment Act, by which Clause 4B was inserted in Article 16, makes it clear that ceiling of 50% has now received constitutional recognition. Where, my lord, by that amendment, the 50% requirement was waived in respect of filling up of backlog vacancies. They are also certain subject to certain conditions. We fully endorse the submission of Sri that extras indicated in para 810 of Indrasani's case were only illustrative and cannot be said to be exhaustive. We, however, do not agree with Mr. Rothi that para 810 provided only a geographical test. The use of expression on being out of the mainstream of national life is a social test which also needs to be fulfilled for a case to be covered by exception. We do not find any substance in any of the 10 grounds to refer the Indrasani for a larger bench. What was held by Constitution Bench in relevance and significance of the principal state, this is clearly binds us. The judgment has stood the test of time and has never been doubted by any judgment of this court. The Constitution Bench judgment of this court in Indrasani neither needs to be revisited nor referred to a larger bench for consideration. The Constitution of Nagaraj does not contain any ratio that ceiling of 50% may be exceeded by showing quantifiable contemporary data relating to backwardness. The Commission has completely misread the ratio of the judgment, etc. Then, one another argument that is so, in the Chevron Leela Prasad Rao, in volume 3, Malars, page 1173. The judgment starts at 1173. Volume 3. The para 113 at 1266.
Yes.
Para 113.
Yes.
What is sought to be achieved by Article 14 and 16 is equality and equality of opportunity. 14 and 16. In Indira Sahni, this court emphasized that founding fathers never envisaged reservation of all seats and 50% shall be the rule. Some relaxation may become imperative, but extreme caution is to be exercised. Then, my lords, 808 and onwards it is extracted. That I skip, and my lords may kindly turn to para 117, my lords, at 1267. The question emanating in this case is how to balance the rights of scheduled castes and scheduled tribes, whether providing 100% reservation in favor of particular class is permissible. 118, the High Court referred to Constituent Assembly debate that that may be not relevant to be read. 119, M.R. Balaji, then my lords, para 121 at 1269. In M. Nagaraj versus Union of India, it was held that ceiling limit of the reservation is 50%, without which the structure of equality of opportunity in Article 16 would collapse. This court held, we reiterate that ceiling limit of 50%, the concept of creamy layer, and the compelling reasons, namely backwardness, the inadequacy of representation, and overall administrative efficiency, are all constitutional requirements without which the structure of equality of opportunity in Article 16 would collapse. Reliance has also been placed on Union of India versus Rakesh Kumar on behalf of the respondents, which related to Articles 243, 243, 15.4, 16.4, and Schedule 5 to the Constitution under Part 9 to extend Panchayat Raj system to scheduled areas. It was held that post of chairperson of Panchayat and scheduled tribes in the scheduled areas cannot be put into a disadvantaged position. Because of the peculiar conditions in those areas, it is permissible that chairpersons of scheduled areas should be exclusively from scheduled tribe only. It was also held that Article 243D envisages proportionate representation and is distinct and an independent constitutional basis of reservation in Panchayati Raj institution. The reservation of 243D cannot be compared with affirmative action measures under 15.4 and 16.4, where a balance is to be maintained between affirmative action measures and merits. This court pointed out through Articles 14, 15, and 16 provide for affirmative action measures. However, there is a need for periodical review, keeping in changing society. The difference between 243 and 16.4 was pointed out in Rakesh Kumar, especially on the unavailability of analogy between 16.4 and 243D. We are in agreement with decision of the Bombay High Court, reported in Vinayak Rao Gangaramji Deshmukh versus P.C. Agarwal. The case that involved a fact situation where chairperson position in a panchayat was reserved in favor of scheduled caste women. In the course of upholding this reservation, it was held. Now, after the 73rd and 74th constitutional amendment, the constitution of local bodies has been granted a constitutional protection, and 243D mandates that a seat shall be reserved for scheduled caste and scheduled tribes in every panchayat under clause 4 of the said Article 243. Also, that the office of the chairpersons in the panchayats at the village or any other level shall be reserved for the scheduled caste. The scheduled caste will have in such manner as the legislature a state may by law provide. Therefore, the reservation of the local bodies like the village is not governed by Article 16.4, which speaks about the reservation of in the public employment, but a separate constitutional power directs the reservation in such local bodies. Then rest of it is only reproduction of Indira Sahni. Para 122.3. It refers to, my lords, the reservation again in local bodies in the state of Jharkhand under the Panchayat Raj Act. Then, my lords, it starts like this. However, in addition to 50% reservation in favor of scheduled tribes, the state of Jharkhand is also under obligation to account for the interests of scheduled castes, etc. Then those circumstances are discussed. Therefore, it said that that would not apply for Article 16(4). Then, my lords, in K. Krishnamurthy, that is referred at para 123.
Yes.
123, my lords, at page 1272. This was in relation to reservation in panchayat, in local bodies in the state of Karnataka itself, where after para 66 as extracted at page 1274. This is very relevant, my lords, because in the state of Karnataka, even in respect of local bodies, Supreme Court has held that 50% shall be the ceiling. Admittedly, this is where I'm at the middle of page 1274. After placitum C, my lords.
Yes.
Admittedly, reservations in excess of 50% do exist in some exceptional cases. There are also, my lords, exceptional cases is pointed out. When it comes to domain of political representation, for instance, the legislative assemblies of the states of Arunachal Pradesh, Nagaland, Meghalaya, Mizoram, and Sikkim have reservations that are far in excess of 50% limit. However, such a position is the outcome of exceptional considerations in relation to those areas. Similarly, vertical reservation in excess of 50% are permissible in the composition of local government institutions located in the 5th schedule. In the recent decision reported in Union of India versus Racket, this court has explained why it may be necessary to provide reservations for scheduled tribes that exceed 50% of the seats in panchayats located in scheduled areas. However, such exceptional consideration cannot be invoked when we are examining the quantum of reservations in favor of backward classes for the purpose of local bodies located in general areas. In such circumstances, the vertical reservation in favor of SC, ST, OBC cannot exceed the upper limit of 50% when taken together, except where scheduled area or difficult terrains are there. The Supreme Court reiterated, even in respect of local bodies, it cannot exceed 50%. Then, my lords, they refer to Vinayak Rao Ganajay Rao, that is 124. The decision of the Bombay High Court in Vinayak Rao regarding distinction between the was affirmed. This court observed that some decisions in the past examined validity of reservation, local self-government, applying principles evolved about employment, education. It was also that for scheduled caste, scheduled on the backwards, the level playing field is sought to be created by conferring reservation benefits. In K. Krishnamurthy, this court emphasized that socio-economic backwardness does not necessarily coincide with the political backwardness, which did not necessarily be emphasized in 15/4. Barriers to political participation are not of the same character as barriers that limit it to education and employment. Concerning vertical reservations, it was said that they have to be made in the upper ceiling of 50%. Insofar as Karnataka is concerned, even in respect of local bodies where proportional representation is spoken of, the Supreme Court reiterated that it cannot exceed 50%. Then, my lords, only one paragraph, that is, my lords, para 166.2 at page 1296. My lords, that is even where, when it came to scheduled tribes in scheduled areas of Andhra Pradesh. One sick question. GOM's 3 of 2000 providing for 100% reservation is not permissible under the Constitution. The outer limit is 50% as specified in Indira Sahni. It was in respect of scheduled areas. What are commonly known as the company districts, they call even today locally, because It was under company rule for long years, even after the British government came. Even today, those districts are referred as company districts, mining districts, very remote districts. Para 168 is the conclusion, my lords. We cannot ignore the fact that a similar GO was issued by the erstwhile state of Andhra Pradesh in the year 1986, which was quashed by the state administrative tribunal, against which appeal was preferred in this court, which was dismissed as withdrawn in the year 1998. After the withdrawal of the appeal, it was expected of the erstwhile state of Andhra Pradesh not to resort to such illegality of providing 100% reservation again, but in GM 3 of 2, which was equally impermissible, even if the AP Regulation Reservation of Public Service Act would have been amended. In that event also, providing reservation beyond 50% was not permissible. It is rightly apparent by the appellant that the state may again, by way of misadventure, resort to illegal exercise as was done earlier. It was at least expected of the functionary like government to act in aforesaid manner, as they were bound by the dictum laid down by this court in Indra Sani and other decisions, holding that the limit of reservation not to exceed 50%. There was no rhyme or reason why the state government to resort to it. It is unfortunate illegal exercise done in 86 was sought to be protected by yet another unconstitutional attempt by issuing GO 2000 with effect from 1986, and now after 20 years have passed, they saving the appointments already made. Here no appointment has been made under the new act as yet. Then, my lords, about the quantifiable data, the sole reliance that is placed by both Nagmohan Das Commission and also Subhash Adi report is on Ratnaprabha report. Ratnaprabha report was not only, of course, no doubt it was accepted in BK Pavitra 2 by the Supreme Court, by 2-judge bench. But subsequently, my lords, in Jarnail Singh, a 3-judge bench specifically referred to Ratnaprabha committee report and said that it is flawed and founded on wrong presumptions. There is, my lords, in Jarnail Singh, volume 4, page 1694. Relevant is at page 1733, para 63. I'll take 5 more minutes, my lords. My lords should permit me.
Tomorrow, you continue tomorrow.
No, I'll conclude. No difficulty, my lords. If my lords have time, I will conclude.
No, we have time. It's up to you.
Very well.
If you want, you can continue tomorrow.
Very well.
And you'll also have to show us those judgments where the ceiling has been breached.
To my knowledge, except in the tribal area where Panchayat Raj institutions.
There are judgments.
That is RC Podial is there, my lord. That is in respect. I'll point out that.
And then you can conclude.
Yes.
Who will be the next council?
The Janhit, my lords, I'll refer my lords to Janhit,
yes,
where they reiterated while upholding 10% reservation for economically weaker sections. They reiterated that in so far as 15.4 and 16.4 is concerned, 50% is ceiling.
Who will be the next in the next matter?
I am in the CIL, but senior counsel is appearing as an
I am
on the petitioners. There are 5 petitions. No?
That's for the petitioner and then the first petition, PI, 30 point.
One is a
CI.
Yes, one is a petitioner in person.
Yes, 30.
That is 30. 30.1.
I am up here.
You are in 30.1.
I'm for 30.4.
Oh. 30.4 pertains to internal reservation, my lord, sir, which has nothing to do with the 50% ceiling.
That's 30.4. Minutes, we had issued a government order where in the subject minutes we had referred to the interim order passed by this in 200. So therefore it got linked by the learned single judge. But it does not relate to 56%.
So we'll delink this.
It can be delinked. It's 30 point.
That could be delinked, my lord, because the issue here and there are totally different.
30.2.
State, my lord, because the roster has been set aside by the KAT. Against that, they are in appeal. They are in writ petition.
So you will answer this first, or you will take this first?
I am entirely at the disposal of.
No, entirely you tell us how you want to.
What I would request is, please give me half a day, any day convenient to the court. Let them complete.
They will complete by tomorrow.
Please give me half a day, any day convenient to the court. I'll finish my argument.
No, we'll continue. We won't stop. You
Please.
continue. It will be a continuing day to day. You finish.
Provided it starts at 2:30, I'll be very happy because it is difficult to make an impact if it is heard only at the fag end of the day.
No, don't worry.
No, for me, I'm an old man. Court should give me some. I'm not that young. So give me half a day.
So young here. It's okay. But we'll give you
any day, half a day, either in the morning or in the evening.
We'll give you an hour on a continuous basis. Minimum an hour we'll give you.
No, I may need half a day.
Half a day is only 2 hours.
2.5 hours, I'll be happy.
2 hours. So you take it over a period of 3 days. It's okay.
Instead of that, in one go, I will be able to finish my arguments.
We won't be able to take up any other matter. People are also waiting for the urgent matter. So
I respectfully agree. Therefore,
any other job to do?
No, in fact, under the rules, a parted matter is entitled to be given priority. Please give that priority to this case because of the importance of the case.
This is why you think we are hearing it day to day.
Half a day, any day convenient. In fact, my lords have been giving due preference to this yesterday. My lords said at 2:30. I never expected my matter would be taken up. Yet my lords were kind enough to take up because to maintain the continuity and tempo.
That's why we are taking up day to day. But if you wanted half a day, then you're bound by half a day. We'll give you half a day, no more. We'll take it up at 2:30 and you end on that day.
Day after tomorrow.
Whatever, let them finish.
Yes, but tomorrow I'll finish.
Whenever we are able to give you half a day, we'll give you half a day.
Great.
That's one submission. First list.
30.2 is the lead letter.
So 35.4 is deleted.
30.4 was not deleted, it is delinked.
Delinked, sorry. Delinked.
30.4 is delinked. It will be taken up separately.
Please.
We'll take up your petition. You'll get your half a day for petition and your response.
Please.
All right. Item 30.4, say the learned counsel for the party state. This issues involved are relating to internal reservation and therefore are not, in that sense, not connected with the and are not similar to the issues raised in WP 25515 of 2025.
There is an
accordingly the
application.
The present petition is delinked from the.
So Ashwini,
there is an amendment application, my lord, in
WP 200448 of 2025. The petitioner in person was here. In the last 2 months. How long will you take?
Well, I am appearing on behalf of.
How long will you take? That's what we're asking.
Mahindra.
How long will you take? Is the question.
I am submitting a written argument.
Written arguments. All right, let's give that. Give a copy to them also. Continue.
That's one submission.
Oh, their job is over.
That's one submission, minutes. List one, serial number 39, minutes. 39.4, there is an IA. We have to notify the mining lease, minutes. The prospecting license was in respect of 1,400 acre for gold, minutes. But I don't know, deposits have been found only for 200 acres, and IA is pending. Any day, minutes, second list, minutes.
Somebody took an adjournment in 39 form, 39 item.
It did not reach.
Yeah, no, somebody mentioned 39.
My lord, serial number 48 in list 1 is a contempt matter for a child who has been taken away and custody has not been handed over. In fact, service is complete, though it says police report not yet received. It's on record. Police report has been received.
We'll give you next week.
Can it be taken next week, my lord? It's Tuesday, Wednesday next week.
Serial number 33, Millards. The state has filed its objection. It's a matter of PIL with regard to the appointment to the consumer commissions. The state has already filed their objections, Millards. A date may be fixed for the final arguments. Kindly.
We'll give you the dates.